Hello everyone, and welcome to the webinar Presumptive Transfer and the Courts. My name is Daniel Richardson. I'm from the Judicial Council Center for Family, Children's, and the Courts. And we're going to be discussing the presumptive transfer process today and the presumptive transfer hearing, which eventually can be held to review the decision on whether or not there should be a waiver to presumptive transfer. With me today is Erica Cristo of the Department of Healthcare Services and Carolyn Catan of California Department of Social Services. They're going to be giving us a detailed presentation on the presumptive transfer administrative process, which is the process that is triggered when a child changes placements to a out-of-county placement, and can eventually be reviewed by the juvenile court if someone requests a hearing. We have an intended audience today of court personnel, so we'll be addressing people that are involved in dependency court hearings, including judges, attorneys, court staff, court-appointed special advocates, social workers, and probation officers. We'll also be addressing county mental health workers and especially mental health care service providers who may want to be familiar with the presumptive transfer process and how it impacts some of their the services and some of their clients that they're providing services to. Our objective today is to really get an understanding of the presumptive transfer process, how it starts, what is supposed to happen when a child is placed in a out-of-county placement. So we're going to be addressing the origins of presumptive transfer, so why the presumptive transfer process was created, what it was meant to address, and why it was necessary. We're going to be going into the administrative process, so we hope that after the presentation you'll understand how the presumptive transfer process starts, what's supposed to happen during the presumptive transfer process. And then at the conclusion of the presumptive transfer administrative process, we'll be getting into how that decision can be reviewed if someone requests a waiver to presumptive transfer, how that decision can be reviewed by the juvenile court. So we want people to know the procedures and requirements of the presumptive transfer hearing, to know the goal of the presumptive transfer hearing, and then also to know the rule of court and the judicial council forms that were created to create this unique hearing that reviews this decision on presumptive transfer. We'll be starting out with a little bit of background on the creation of the presumptive transfer process and AB 1299. Then we'll be getting into the presumptive transfer administrative process, where Erica and Carolyn are going to give us a breakdown of that process and how it works. And then finally, we'll go into the presumptive transfer hearing and how that hearing is to be conducted and the rules of the hearing and the judicial council forms related to it. So when you're looking at the presumptive transfer legal scheme, this is where you'll be looking. Welfare and Institutions Code, Section 14717.1. Rule of Court 5.647, which was created to address the hearing, the presumptive transfer hearing. So the Rule of Court is not going to be addressing the administrative process of presumptive transfer. That is addressed in All County Letter 1777 and All County Letter 1860. And regulations are also required by the statute, and those are currently pending. The statute has them due by July 1st, 2019, so also look out for those around this summer. I would just want to note that the administrative process is implemented by the Department of Healthcare Services and California Department of Social Services. We have representatives from each of those departments here today. The legislature gave those departments a lot of authority to implement the presumptive transfer process, so we do rely heavily on the all county letters that we currently have, 1777 and 1860, and then of course the regulations that will be due this summer. So with that, I'm going to hand it off to Erica to give us some background on presumptive transfer and AB 1299.
Thank you, Daniel. This is Erica Cristo, again, from the Department of Healthcare Services, Mental Health Services Division. I'm going to go over a little bit of background about presumptive transfer, or sometimes we call it AB 1299. It's important to note a little bit of framework and background for the statute because there are many parties involved, all having various levels of expertise and information. So we want to set a little framework for you today. So AB 1299 was the statute that was passed in 2016 to address a longstanding issue of access to specialty mental health services for children in foster youth that are placed outside of their county of jurisdiction. There were many previous efforts at the state level for many years to address this issue, but the statutory solution was promulgated through the passage of AB 1299. So prior to AB 1299, the county of jurisdiction for the child in foster youth remained responsible for the authorization, arrangement, and payment for specialty mental health services when a child was placed in another county. And that presented some administrative and logistical barriers to care in maybe not having a relationship with the county that was where the child was placed, or knowing the providers that were there. And ultimately, sometimes that resulted in children in foster care that were placed outside of their county of jurisdiction experiencing delays to needed mental health services, especially at the time when they are in a particularly vulnerable time with having to change placements. So some other issues with the old way of doing business were that, as I highlighted before, there were sometimes difficulties with the county of jurisdiction finding providers and services in a new county that they may not be familiar with, seeking treatment authorizations from the county where the child was living, coordinating and monitoring care at a distance, and then ultimately securing reimbursement from whoever it was, whether it was the provider in the other mental health plan or the mental health plan itself, making a payment to the county who was authorizing services. So these were some of the administrative and logistical barriers that contributed to lengthy delays in children and youth receiving services when they were placed outside of their county of jurisdiction. And these are some of the problems that AB 1299, or presumptive transfer, is geared to address. So quickly, I'll go over a little bit about the presumptive transfer process and some basic information about mental health plans and their responsibility for providing specialty mental health services. So in this section, we'll go over specialty mental health services and the mental health plan's responsibility for providing them, presumptive transfer and what it means, child and family teams, and exceptions to presumptive transfer, and how the applicable definitions, and then how that is determined. So you've heard me say the mental health plan a few times, and the mental health plan is essentially the county in each of the counties throughout California. The county mental health plans are responsible for authorizing, arranging, and paying for specialty mental health services. They do that under a contract with the Department of Healthcare Services at the state, and the state delegates its authority under the Medicaid program to the mental health plans to provide the array of specialty mental health services. And the counties then the county mental health plans either provide services directly under their contract with the Department of Healthcare Services, or they contract out to provide those services, and most counties do a combination of both. So as I mentioned, specialty mental health services are a carved out set of services that are intensive rehabilitative services that are provided through county mental health plans under the Medicaid or the Medi-Cal program. To receive specialty mental health services, Medi-Cal beneficiaries need to meet what's called medical necessity criteria, and that involves having a covered diagnosis, specific impairments, and being able to meet certain intervention criteria. Many people may be familiar with the early and periodic screening, diagnosis, and treatment program within the Medicaid program, and what that is a special provision under the Medicaid program applicable to children and youth under the age of 21. And because of EPSDT, or early and periodic screening, diagnosis, and treatment services, the medical necessity criteria for children is less stringent than it is for adults. And it's always important to remember that when talking about medical necessity criteria, because it's easier to meet the criteria for children and youth than it is for adults, because the intervention criteria is less significant, geared to having children be able to progress at the developmental age that's appropriate for them. Children and youth and non-minor dependents in the foster care and juvenile justice system are categorically eligible for Medi-Cal, and therefore if they meet the criteria for specialty mental health services, they may receive those through the mental health plans. Moving into presumptive transfer, there are some exceptions to presumptive transfer that we'll address in the coming parts of the webinar. But essentially, presumptive transfer means that unless there's an exception, responsibility for providing or arranging for specialty mental health services shall promptly transfer from the county of original jurisdiction to the county in which the foster child resides. So that means that if a child is placed outside of their county of original jurisdiction, the county where they're placed retains, assumes the responsibility for providing specialty mental health services to that child, and they are treated like any other child that originally lived in that county and considered part of the new county's caseload. When a child or youth, a foster youth is placed outside of his or her county of jurisdiction, again, the responsibility for arranging and paying for specialty mental health transfers to the new mental health plan or MHP in the county of residence, unless there is a waiver, and the waiver has been approved, which we'll discuss as we go on throughout the webinar. So at this point in the webinar, I'm going to turn the microphone over to Caroline Catan to take over from this.
Thank you, Erica. Okay, so going back just a little bit, separate and apart from presumptive transfer, child welfare agencies are required by statute to notify parents and the child or youth, as well as the youth's attorney, at least 14 days prior to an out-of-county placement. As I said, that is separate and apart from presumptive transfer. Juvenile probation agencies are not subject to that same statute, but we do hope, for the purposes of presumptive transfer, probation agencies should still provide notification as soon as they know that an out-of-county placement may be made. So, when placement decisions need to be made, it's really important that those decisions are discussed and made within the context of a child and family team. The child and family team process is really intended to help children and families discuss issues and make decisions collectively, and so that issues can be shared and concerns can be addressed face-to-face and in a way that keeps everybody informed. And so that includes addressing the mental health needs that maybe a child or youth may have and the services that they are receiving. So when that CFT process is effective, the child or youth case plan will include services and supports that reflect the voice and preferences of the child and family, and the providers of services will be included in the way that those services are developed. And so we really do think that presumptive transfer really fits in nicely with the child and family team process. And so when the placement will be made out of county, the child and family team process is really where counties should look to make those decisions and make sure that everybody is on board and everybody understands what the decision is going to be and what the impacts of that decision mean in terms of services and in terms of what may be the impacts and how to address the changes that are going to happen. Make sure everybody is on board. So as you can see from this slide, there's quite a lot of factors that come into play. The CFT will discuss a variety of things, and it's important that all of these issues are discussed and shared among all of the team members as soon as an out-of-county placement is being considered. When an out-of-county placement is an issue, that CFT process is also an opportunity to ensure that notification requirements that are part of the presumptive transfer process, the CFT meeting can be an opportunity to begin that notification process. So the conversations that you're having with the CFT should include making sure that there is understanding and awareness of what presumptive transfer is, what the process is, what does that mean will happen, what are the rights that a child and family have in terms of requesting a waiver if that's what if they don't think that presumptive that the mental health services should change to the new county, how do I find forms and whatnot. Is there a need to have a transition plan? Because if my mental health provider is going to change, what does that mean? So how do I make sure that those things happen smoothly? If I'm a child receiving services and I'm concerned about these kinds of logistical questions, those questions should be addressed within the child and family team, so that I can, share my concerns and ask my questions and get answers and make sure that they are addressed within the context of that child and family team. So as I mentioned just previously, the placing agencies do have a requirement to provide notification when there's going to be a placement made out of county. They are required to make notification separate from the presumptive transfer process as well as part of the presumptive transfer process. The presumptive transfer notification that they have to make, it does have to be made to these specific individuals, the child or youth, the child or youth attorney, the person responsible for making mental health care decisions on behalf of the child or youth, as well as the CFT coordinator. We do provide you with a sample informing notice in ACL 1860 and Mental Health Services Information Notice 18-027. That notice does need to be provided in writing, and it does need to explain what all of the things that were discussed just previously on that previous slide about presumptive transfer and the right to request a waiver. All of these items here. So it really is important to make sure that these things are addressed and made clear to the child and family team so that they can be addressed clearly, and then as well with that informing notice. So the exceptions to presumptive transfer that Erica had mentioned previously are also part of the informing notice that you are providing to counties and to families, to children and family teams and whatnot. So an exception to presumptive transfer means that you are keeping the responsibility for specialty mental health services in the county of original jurisdiction, and that including if you're going from one out-of-county placement to another. But that's all that it means. It just means that it's an exception to that presumptive transfer policy. If any of these four conditions are determined to exist, these are the exceptions. So if transferring the responsibility for specialty mental health services would disrupt a child or youth continuity of care, if the transfer would interfere with family reunification efforts, if the placement out-of-county placement is expected to last less than 6 months, or if the out-of-county placement is within 30 minutes of travel time, these 4 are the only exceptions to that presumptive transfer policy that the statute allows for. If any of those 4 exceptions exist, a waiver can be requested. So a waiver can be made by any of these individuals: the child or youth, the person or agency responsible for making mental health care decisions on behalf of the child or youth, the child or youth attorney, or the child welfare or juvenile probation agency. And the request to waive presumptive transfer must be made to the placing agency within 7 calendar days of the informing notice. And so that informing notice that was made really does become important. Again, the exceptions and a request for a waiver are also things that should be discussed within the context of a child and family team, so that it's known by all of the team members whether or not a request for a waiver is what's in the best interest of the child or youth, and what will happen, so that everybody is on board and aware of what's going to happen next. So placing agencies, when they are making a determination about a request for a waiver, are required to consult with the child and family team when they make a decision about that waiver request. Again, if there has been discussion about with the child and family team, that shouldn't be a surprise, the fact that they've got a waiver request, because they should have been part of the conversation that took place within the child and family team. When that determination has been made, placing agencies are required to provide written notification of that determination to the person who requested the waiver, as well as the other parties to the case. So, the placing agencies do have quite a number of waiver responsibilities. They've got to make sure that all of the required legal parties are notified that a request for a waiver was received. They've got to make a determination that at least one of the required exceptions does in fact exist. Consult with the CFT and other professionals who may be serving the child and family. And then they have to make a determination on an individual basis whether or not a waiver of presumptive transfer is appropriate. Following that, they just make sure that they then are properly informing all of the required individuals of what their determination is. And then lastly, if there is a request for a judicial review of their determination, there is a report that is required that they make to the court.
Thank you, Caroline. This is Erica Cristo again. The last words on waivers is that waivers are conditional. So Caroline just went over the exceptions to presumptive transfer where a waiver may be considered or appropriate. But beyond meeting the conditions for an exception, the mental health plan in the county of original jurisdiction, in order to have the waiver take effect or be approved, must demonstrate an existing contract with a specialty mental health care provider or the ability to enter into a contract within 30 days of the waiver decision. That's an important thing to take into consideration in order for a waiver to take place. And the rationale behind that is that besides just having the exceptions for presumptive transfer that Caroline just went over, the county, if it's going to retain responsibility for providing the services, the county of jurisdiction needs to have a way to do that, and that's why that's put in there as a condition. They need to have a contract in place or the ability to quickly do that within 30 days in order to be able to carry out the responsibility of continuing to provide services. During the waiver process, it's important to make sure that that services do continue, and that even though there may be a question for a moment about if a waiver will take place or who will retain responsibility or if the presumptive transfer will take place, it's important that the child continues to receive services during that time. So when a request for presumptive transfer is made, the MHP in the county of jurisdiction needs to continue to provide specialty mental health services for the child or youth until a final determination on the waiver is made. And it's a very important thing to remember because whether or not the MHP that provides services will change, we don't want children to not receive services while that decision is being made. If presumptive transfer will not be waived, the transfer of responsibility to the mental health plan in the county of residence becomes effective on the date of placement. Hopefully in that time, the county of residence will be aware that the child is coming and be prepared to start providing services upon the time that the child is placed in their county. So with that, I'll turn it back over to Daniel, who will be starting to talk about the presumptive transfer hearing process.
Okay, thank you, Erica. So now we're going to be moving on to discuss the presumptive transfer hearing and what happens when there's a disagreement about the determination on the waiver request. So a request has been made for a waiver, and the placement agency's determination, for whatever reason, someone is in a disagreement with that. They do have the option to request a hearing to have that decision reviewed by the juvenile court. So we're going to be talking about that hearing in this section, who can request a hearing, how that request needs to be made, timelines for requesting the hearing, and then the hearing itself, what is the burden, what is the court going to be deciding, and what's the evidentiary standard. We're going to be looking a lot at Rule 5.647, which was created to create this unique hearing, and we're also going to be discussing the judicial counsel forms, which most of them are mandatory. So when you are making these requests for hearings, the judicial counsel forms are mandatory. So the presumptive transfer hearing, if you look at Section 14717.1D4, that is the origin of the presumptive transfer hearing. And as it says, it arises when someone does request an exception to presumptive transfer, and that person or any party who disagrees with the determination made by the county agency can request a hearing, and the court can grant a hearing if that request is made. So if you look at the language, the court may set the matter for hearing and may confirm or deny the transfer of jurisdiction or application of an exception. So the court really can make a determination on whether or not the hearing is set. There's quite a bit of discretion for the juvenile court to set a hearing or not. One very important point to make when you are approaching a hearing, the policy guidance and regulations that we've been discussing under All County Letter 1777 and All County Letter 1860 include a couple of key concepts for the hearing itself, and we're going to be discussing what those are in a second. But the Department of Healthcare Services and California Department of Social Services play a very large role in implementing AB 1299. They've set up the structure for how to make decisions on exceptions to presumptive transfer and how presumptive transfer needs to proceed. So the legislature did essentially grant them this authority to make to implement the process, and some aspects of that process do have an effect on the conduct of the hearing. For example, the timeline for when a hearing must be requested. This is not addressed in the rule of court. This is something that the policy guidance addresses, and in ACL 1777. So the timeline is 7 calendar days. The reason that the rule of court doesn't address this particular aspect of the hearing is because it was considered to be an administrative function, and the placing agency needed to have responsibility for determining when the presumptive transfer needed to occur after the process was done to determine exceptions. And these policies may change in the future. Regulations are pending. They're due July 1st, 2019. So just to reinforce the point that when you're looking at the timeline for when you must request a hearing, you have to check the policy guidance or the regulations. The other aspect where the policy guidance and regulations come into play is one of the individuals that can request a waiver to presumptive transfer is anyone who owns a legal duty to the child as defined by the department. And we'll talk about this again in a little bit, but right now that is defined as the child's attorney. And as we've been discussing, all pre-hearing requirements, notice requirements, decision-making on requests for waivers are determined by the policy guidance and the pending regulations. So I just alluded to this a second ago. The individuals that can request a hearing is the person who requested the exception to presumptive transfer or any party to the case. So for a court that is considering whether or not to grant a hearing on presumptive transfer, the first issue is this person entitled to request a hearing? If they are the ones that requested the exception or the waiver to presumptive transfer and they had a determination made by the placing agency, they can request a hearing to review that determination. And then also any party to the case, so the child, the parent, the guardians, they can also request a hearing to review the decision on presumptive transfer. So who can request a waiver? This is in Welfare Institutions Code section 417.1D3. Again, this is to determine who requests a waiver is also the person that can request a hearing. So the foster child or non-minor, the person or agency responsible for making mental health decisions, the probation officer or social worker, or the fourth category, any interested party that owes a legal duty to the child involving the child's health or welfare as defined by the department. So that's a very key language at the end. That is going to be defined by the Department of Health Care Services and the California Department of Social Services. And right now, they've listed the child's attorney as an individual that owes a legal duty to the child that can request a waiver. Again, so we touched on this, the timeline to request a hearing, 7 calendar days. It's outlined in ACL 1860. And this is when the request is made for presumptive transfer, the responsibility for arranging for mental health services remains with the county of original jurisdiction, which is something that we've talked about in previous slides. So when you are requesting a hearing, JV Form 214, the request for hearing on waiver of presumptive transfer form was created. And this form is what's supposed to be used after the determination has been made on the request for a waiver of presumptive transfer. It's a mandatory form. It requires some basic information about the nature of the request. And one thing to also point out is that this form also needs to be served on the placing agency within 7 days of being notified of the decision by the placing agency on the request for waiver. The reason for this is so that the placing agency knows that there is a request for hearing so that they can pause the presumptive transfer process until the request for hearing is resolved, either by the court not granting a hearing or the court holding a hearing to make a determination on whether or not there should be a waiver to presumptive transfer. One of the key pieces of information that the court is going to want to know is why the request on the waiver for presumptive transfer is in the child's best interest. So that's going to be addressed in number 7 of the form. And you can attach further information if you need to, if there's not enough room on the form. But you really want to make sure that the court knows what exactly is at stake for the child, and why your position is in the child's best interest. The hearing can challenge the placement agency's determination in a couple of ways. So the placement agency determination that that the waiver does not apply to presumptive transfer can be a basis for a hearing, or the placement agency's determination that an exception does apply to presumptive transfer can also be challenged. So in the first instance, if someone has requested a waiver of presumptive transfer and the agency determined that there should not be a waiver, that person who requested the waiver or any party to the case can request a hearing. In the second instance, when the placement agency determines that an exception does apply to presumptive transfer, in that situation, any party to the case would be able to request a hearing to challenge that decision. So when the court is considering whether or not to grant a hearing or not, a form was created, JV Form 214A. And as I mentioned earlier, the court has quite a bit of discretion to determine whether or not a hearing should be granted or not. The hearing is supposed to be held, if a hearing is granted, it's supposed to be held no later than 5 days after the request for hearing was filed. And this timeline is very short because services are at stake for the child, and the intent was to try to have a hearing as quickly as possible so that the issues related to their services can be resolved as quickly as possible. If no hearing is granted, the placement agency's determination becomes final. So if the court denies the request for a hearing, whatever the placement agency decided on the request for waiver will be the final determination. And when a hearing, this form also is a notice form as well. After the hearing is set, if a hearing is set, the clerk is required to send notice to the following individuals listed here. So you can use this form as the notice form, which will include the court's order, and it can be delivered to the individuals that are required to receive notice. Now, so if a hearing is set, there is a requirement in the rule that the case-carrying worker prepare a report within 2 days after it grants the hearing. Again, this is a very quick timeline. I know it's going to be hard, for social workers and probation officers to meet that deadline. We did use this timeline in a similar rule on education stability. Has the same timeline for when a child's educational placement is being changed. They also have a right to review that decision, and we basically this rule basically copies the same timelines from that rule. They both require a hearing to happen pretty quickly. So hopefully most of this information will already be in possession of the probation officer and social worker, and they can produce a report pretty quickly. But they basically the report should detail the rationale for the placement agency's decision on the waiver request, that they've consulted the child, the non-minor parents, and the child and family team, and others who serve the child on the waiver determination. The report should also detail that notice was provided to the individual who requested the waiver and to the parties, because that's going to be important whether or not for the timelines for when the hearing was requested. And as we talked about, exceptions to presumptive transfer are contingent on the county of original jurisdiction being able to provide those services. So that information has to be in the report as well. So the information that you see there. And then how are the child's current provision of services, special mental health services, going to be impacted by the presumptive transfer determination? So that's really going to be one of the key issues that the court is going to be looking at, is how are services going to be impacted for the child or non-minor. So at the hearing, the court may confirm or deny the transfer of jurisdiction based on the best interest of the child, and that's reiterated in the rule of court. This whole thing really needs to be resolved looking at the best interest of the child or non-minor, and how, as I said, how are services for them going to be impacted, and what is going to be in their best interest. So this is the key inquiry when making a determination on how to determine whether or not an exception should apply to presumptive transfer. And when we're looking at the hearing itself, the person that requested the waiver presumptive transfer has the burden to show that a waiver is in the best interest of the child by a preponderance of the evidence. Now, the reason that the waiver or the burden is on the person that requested a waiver instead of the person that's requesting a hearing, because sometimes they may not be the same person, is that the presumptive transfer is a presumption, and so the person that is arguing that there's an exception to that presumption, it was determined that they had the evidentiary burden. As I was saying, this is expected to be a very fast, quickly held hearing. The rules requires that it be concluded within 5 court days. There is an allowance for a continuance if there's good cause under 352 or for probation used under 682. Good cause is sometimes used a little loosely. I would just encourage everyone to if there's any kind of issue with the child services being impacted by a continuance in the hearing, to do everything that they can to ensure that the hearing can be held within 5 court days or as quickly as possible after that. Once the court is ready to make its decision on the request for a waiver to presumptive transfer, JV Form 215 was created for its findings and orders. This also is a mandatory form. The court is going to have to make findings on whether the report was timely, identifying who requested the waiver, the placement agency's determination on that request, that the child and family team was consulted and when that was, that there was proper notice of the determination on waiver, and then the key decision whether or not waiver is in the child or non-minor's best interest. Most of these issues should be addressed in the social worker or probation officer report. Also, this could be a full hearing where other evidence is considered, and so the court will be able to rely on whatever evidence is presented at the hearing. Number 9 on the form is where the court makes this decision on the waiver presumptive transfer, that it was in the best interest, that it is in the best interest or not in the best interest, and then that important contingency that the mental health plan in the county of original jurisdiction has the existing contract to provide services or the ability to do so in 30 days. So the court cannot grant an exception to presumptive transfer unless that is true. So that is a very important point for everyone that's involved in these hearings. The rule also gives some factors to consider when considering the child's best interest or the child or non-minor's best interest: access to mental health services and the impact on those relationships, impact on reunification services, how long the new placement is expected to last, and then the child or non-minor's attorney's position on presumptive transfer. This is not an exhaustive list. There's obviously, this is going to be a case-by-case decision, and the court can look at any number of things to determine the child's best interest in these cases. So just a quick note for youth that were in and out of county placement as of December 31st, 2017, and who are still in out of county placements. If they haven't had the presumptive transfer process because they may not have had a move since that placement in 2017, if you have a child or non-minor in that situation, just do the presumptive transfer process as soon as you can. It's expected that those would be done prior to their first status review hearing in 2018. So at this point, they should just be done whenever everyone becomes aware that process is needed. So in addition to help individuals that are involved in the presumptive transfer process have some information about the process and an explanation, a information sheet was created, JV 214 info, and this information sheet, as plainly as possible, describes the presumptive transfer process. It lists the exceptions, and it gives instructions on how to request a waiver and how to eventually request a hearing. So this information sheet can be distributed to any individuals that are involved in the presumptive transfer process, including the parents or the guardians or children or non-minors, and also attorneys and social workers or anybody else that needs a little bit more clarification on the presumptive transfer process and how it can lead to a hearing. So we hope that people will use this and distribute this to those individuals. So this is a summary of the Judicial Council forms that we've been discussing. 214, the request for hearing, 214A, which is the court's order on the hearing, and then also is the notice form that can be sent out to notice the individuals about the presumptive transfer decision. We just discussed the 214 information sheet, and the 215 is the order after hearing for the court's findings and orders after making a presumptive transfer determination after holding a hearing.
So that concludes the discussion on presumptive transfer. We went through the administrative process, and we touched on, we went through the court hearing. We hope that everyone now fully understands presumptive transfer and how it works. We understand it is a pretty complicated process, but just some closing thoughts, and I'll invite everyone to also join in here. One of the key things, I think, is to start the conversation about presumptive transfer, letting people know what presumptive transfer is, what their rights are, and incorporating that into the child and family team process. This is how things are really going to get off the ground so that people know how this works and what they can do. So that's going to be a very key thing. Another thing is really just that we're talking about the best interest of the child or non-minor, and we all need to work together to implement this process and to ensure that the child or non-minor's best interests are being addressed. So it really does take a team effort, and do you guys have anything to add to that?
Thank you, Daniel. This is Erica Cristo again from Department of Healthcare Services, and I want to echo what Daniel said about the importance of the child and family team and working together with all of the parties involved. It's really important to have good communication among the parties with presumptive transfer, and we would encourage you to make sure you know who those people are in your counties. We do post a list of all of the presumptive transfer county contacts, points of contacts on the CDSS website. We would want to refer you to that reference and make sure you know who to contact when these cases come up, as they are critical, and these children are often in times when they really need services immediately. So I would just want to close with that and just reminding the folks of the key component being good communication.
Agree. This is Caroline Catton again, and I would echo that same thing. I think it's crucial that everybody be working together to make sure that we are helping the kids and families receive the services that they need, and that we're doing it in a way that that reflects what's best practice and helps everybody make progress and continue to move forward. It's a shame when our administrative barriers are what's standing in the way of kids being able to access the care and services that they need. And so anything we can do to try to overcome those barriers, I think is important. So I think it's best if we can err on the side of inviting the folks to the meeting. You know, that's, so when there's a question, just, you know, make a phone call if you can, please, and so that we can reach out to the other county and find out. It doesn't matter if you don't know who the provider is. Just you know, invite somebody to the meeting and ask a question and find out how you can get somebody there. Even if they can participate by phone, it's helpful. So.
Right.
Right. So we need everyone involved, and we need everyone to work together to promote the best interests of children who are in foster care and non-minors. So we understand that there will probably be a lot of questions. We didn't have a chance to do a question and answer session on this webinar, but our emails are provided here. We want to thank you all for participating in this webinar. We hope it was helpful and wish you all the best of luck in your work. And to please feel free to reach out to us if you have any questions. Thanks so much.